Welcome, everyone. We're really excited today to kick things off with a deep dive into something crucial for so many couples. The K-3, conditional resident, and immediate relative visa processes.
That's right. These are the main visa pathways U.S. citizens use to bring their non-American spouses home to the States.
Exactly. And this is going to be a two-part series because there's quite a bit to cover. So let's dive into part one. Our goal here is really to give you clear, detailed, and importantly, actionable insights.
We want this to be a critical resource, whether you're going through this yourself or perhaps advising someone who is.
Absolutely. We'll be looking at definitions, eligibility, and why some of these options are frankly more relevant than others in 2025. Now, before we get started, if you truly appreciate these deep dives, it really is essential that you like, follow, subscribe, maybe leave a comment. It genuinely helps boost the channel's reach.
It makes a huge difference in helping us help more people. So thank you for taking the time. If you can do that, it means a great deal to us.
It really does. We also absolutely want to acknowledge attorney Chris Ingram and his dedicated legal team. They did fantastic work researching and preparing all this legal research for us today.
They really did. And they'd love to work with you if you find yourself needing assistance down the line.
Which brings us to a crucial point, our disclaimer. Please remember that this discussion is for informational purposes. It should not be regarded as legal advice specific to your situation.
That's key. Every case is different.
It is. So if you do need personalized advice, you can schedule a complimentary consultation by visiting www.breakthroughusa.com. We are definitely thrilled to be able to present this topic for you today.
And just to set the stage strategically, attorney Chris Ingram often puts it this way. Reuniting with your spouse in the U.S. is like climbing a mountain, but with the right guide, the summit is within reach.
I like that analogy.
Yeah, and we're here, hopefully, to be part of that guidance, leading you every step of the way, focusing on the most stable routes up that mountain.
Okay, a great framework. It really helps ground what can feel like a very bureaucratic process. So let's start with the basics. Foundational definitions. What exactly are these spousal visas, and why are there different types?
Okay, so at their core, spousal visas are simply the immigration pathways that allow a U.S. citizen to bring their foreign spouse to live in the United States. Sometimes temporarily, sometimes permanently.
Right. And we're focusing on three main categories today.
Correct. The three primary ones. First up is the K-3 visa. Now, the really key thing to grasp here is that it's defined as a non-immigrant visa.
Non-immigrant, meaning temporary, not leading directly to a green card.
Exactly. It was historically designed for temporary stay only. The idea was to let the spouse come to the U.S. while their actual permanent residency case was slowly grinding through the system. It was a bridge.
A bridge, not the destination. Got it. Okay, what are the other two?
The other two are the destination. These are the conditional resident visa, often called the CR visa, and the immediate relative visa, or IR visa.
CR and IR.
Right. And both of these are defined as immigrant visas. That's the crucial distinction. Immigrant visas.
Meaning they lead straight to permanent residency. To the green card.
Yes, directly. As soon as the foreign spouse enters the U.S. on one of these visas, they are a permanent resident.
Okay, so we have the temporary bridge, the K-3 versus these two permanent routes, the CR and IR. You mentioned the choice between CR and IR depends on something specific.
It almost entirely hinges on how long the couple has been married. That's the main deciding factor between CR and IR.
Marriage duration. Okay.
Yeah. So when you're deciding which path makes sense, you really need to look at, three things. How long have you actually been married? How urgently do you need or want to be reunited? And what are your long-term goals? Obviously, permanent residency is usually the goal.
Right.
And since the CR and IR options grant that permanent status immediately upon entry, they're just inherently much more attractive these days. The choice between those two really comes down to whether you hit the 2-year marriage mark, which we'll definitely get into.
Okay, so understanding eligibility, the benefits, the limitations, especially for the K-3, is critical for making an informed choice.
Absolutely critical. You need to weigh those factors.
The non-immigrant versus immigrant distinction is huge. But, the data that attorney Chris Ingram's team pulled on the K-3 is, pretty eye-opening. Let's spend some real time unpacking the K-3, its history, how it's supposed to work, and frankly, why it's almost irrelevant now.
Yeah, the K-3 story is interesting. It really has a very specific historical context. It came about back in 2000 under the Legal Immigration Family Equity Act. People usually just call it the Life Act.
The Life Act, okay.
And its sole purpose, the reason it was created, was basically a compassionate measure. It was meant to deal with the massive backlogs in processing the main permanent residency petition, the Form I-130.
The first step in the green card process.
Exactly. Back then, it was taking couples, well over a year, sometimes much, much longer, just to get that initial I-130 approval.
Wow, a year or more just for step one. That's a long time to be separated.
Yeah. A very long time. Huge family separation issues. So the K-3 was designed specifically to shorten that separation by allowing the spouse to come to the U.S. temporarily while waiting.
Okay, so it was a fix for a specific problem. Slow I-130s. How did a couple actually qualify for this temporary bridge visa? What did the application look like?
Well, this is where it starts getting a bit complicated, and honestly, why the whole thing became so cumbersome. First, obviously, you need a legal marriage. That's standard.
Right.
But the complexity kicks in right away because the U.S. citizen petitioner had to file two separate, distinct petitions with USCIS, basically running two cases in parallel.
Two petitions. Okay, what were they?
So track one was the main permanent residency petition, that Form I-130, which is meant to prove the marriage is legitimate, the bona fides.
Standard procedure for any marriage-based green card.
Correct. But then track two was for the temporary entry. And this is the really counterintuitive part. They had to file Form I-129F, which is the petition for alien fiancé.
Wait, hold on. Form I-129F, the fiancé petition. But you just said they have to be married already to even start this process. That doesn't make sense.
I know. It sounds completely illogical, doesn't it? And that right there highlights what a sort of administrative kludge or workaround the K-3 really was.
So why use a fiancé form for a married person?
It boils down to legislative expediency, really. The I-129F petition process already existed as a way to grant temporary entry specifically for fiancés coming to the U.S. to get married.
Okay.
So when Congress passed the Life Act to help already married couples, instead of designing a whole new form and process just for the K-3, they essentially piggybacked on the existing I-129F framework. It was seen as the fastest legal tool they had available to get a temporary non-immigrant visa stamp into the spouse's passport quickly.
So it was like using an existing tool for a new job, even if the label didn't quite fit. An administrative shortcut.
Precisely, an administrative shortcut. And that mismatch, using a fiancé form for a spouse, is one of the big reasons the K-3 process is just so prone to confusion and, frankly, administrative problems today.
Okay, I think I get it now. A legislative workaround. So after filing both the I-130 and this repurposed I-129F, what was the next step for the couple?
Right. So after those two petitions were filed with USCIS, the foreign spouse, who has to be living outside the U.S. at this point, would then apply for the actual K-3 visa stamp at a U.S. embassy or consulate in their home country.
The consular processing stage.
Exactly. And that involves the standard consular interview. The officer there needs to verify, is the marriage real? Is the applicant otherwise eligible? They check for things like potential public charge issues, any criminal history that might make them inadmissible. Standard checks.
And if everything checks out at the interview?
If approved, the spouse gets the K-3 visa stamp, enters the U.S., and they're allowed to stay initially for a 2-year period.
Okay, they're in the U.S. You mentioned it's temporary. They don't have full rights immediately, do they?
No, not at all. That's another layer of complexity. Once they arrive on the K-3, they still have to apply for separate permits if they want to work or travel.
Separate applications?
Yes.
Even after getting the visa?
Yes. They need to file for an employment authorization document, the EAD, if they want to work legally. And if they plan to travel outside the U.S. and come back while their main green card application is still pending, they need to apply for advance parole. Without advance parole, leaving the U.S. could be seen as abandoning their case.
Wow, so more paperwork, more waiting, even after arriving.
Definitely. And the most critical point, the absolute bottom line here, even after jumping through all those hoops, the two initial petitions, the consular interview, getting the EAD and advance parole, they are still not permanent residents yet.
Still not holding a green card.
Correct. The K-3 status is temporary and conditional. While they're inside the U.S. on that K-3 status, they must take the final major step, filing Form I-485, which is the application to register permanent residence or adjust status.
Ah, the adjustment of status application.
Yeah.
That's the one that actually converts their temporary status into a green card.
Exactly. That's the application that finally gets them permanent residency. So you can see it's a multi-stage, quite complex, and frankly expensive process overall.
It really sounds like it. And what about children?
Right. Unmarried children under 21 could typically accompany the parent on a related K-4 visa following a similar linked process.
Okay, now let's pivot, because everything you've described sounds complex, but maybe worth it if it sped things up significantly back in the day.
Yeah.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
But the data from our legal team, it paints a very different picture for 2025. Let's hit the listener with those numbers. Why is this pathway basically obsolete now?
Yeah, the statistics are, well, they're quite stark. They really leave no room for doubt strategically. In 2025, the K-3 visa is, for all practical purposes, extinct.
Extinct, that's a strong word.
It is, but the numbers back it up. Our team's research confirmed that in the entire fiscal year of 2023, globally, only 6 K-3 visas were issued.
Wait, 6? Not 6,000 or 600,
Yeah.
just 6. 6 visas worldwide.
6 single digits for the entire planet, for the entire year.
That is absolutely staggering. It's not just unpopular, it's like the system actively prevents it from being used.
It strongly suggests that, yes. And the risk factor is enormous, compounded by the refusal rate. Looking at the year before, 2022, only 16 applications even made it to a final decision point.
16 total.
And out of those 16, 11 were refused.
11 out of 16 refused. That's, what is that, a 68% refusal rate?
A 68% refusal rate
Yeah.
for a visa category that was originally intended to be, compassionate and helpful.
That's incredibly high. What does that signal?
It signals, almost certainly, intense scrutiny from consular officers. They know how rare these are. They know the administrative instability. It suggests they're looking for any reason to deny, probably because the underlying logic of the visa itself has collapsed.
Okay, let's drill down into that collapse logic, the core structural problem. You said the K-3 existed because the I-130s were slow. What happens now that I-130 processing has improved? What happens to that K-3 application if the I-130 gets approved first?
And that right there is the fundamental bureaucratic trap of the K-3 today. The entire reason for its existence vanished.
Because the I-130s are faster now.
Exactly. Processing times for the Form I-130, the permanent petition, have improved dramatically. They often fall somewhere in the, say, 9 to 15-month range now, sometimes even faster depending on the case specifics and service center.
Okay, 9 to 15 months. And how does that compare to the K-3 timeline?
That faster I-130 processing now frequently outpaces the timeline for getting the K-3 processed. Remember, the K-3 involves both the I-130 and the I-129F, plus consular steps. It just takes longer.
So the permanent visa process catches up to or overtakes the temporary one.
Precisely. And here's the kicker. If the I-130, the permanent residency petition, gets approved by USCIS before the K-3 visa process is finalized at the consulate.
Which is likely, given the timelines you just mentioned.
Very likely. Then the K-3 case is automatically subject to administrative closure.
Administrative closure. What does that mean practically?
It means the government basically says, okay, the I-130 is approved, the permanent path is ready to proceed, therefore the temporary K-3 visa is no longer necessary. The legal basis for the K-3 just evaporates.
So the K-3 case just stops. It gets canceled.
It gets terminated, administratively closed, and the couple has spent, potentially thousands of dollars in government filing fees for both petitions, plus legal fees if they used an attorney, and months, maybe over a year, of effort and waiting.
All for nothing.
All for a pathway that the system is essentially designed to shut down prematurely now. And typically those filing fees, they're just gone. The time invested, lost. You're basically applying for a temporary fix that is almost guaranteed to be canceled before it even helps you.
Wow. Okay, so to use the phrase from attorney Chris Ingram's team again, the K-3 really is a dusty trail few travel. high risk, way too many steps, that shocking 68% refusal rate, and this huge risk of administrative closure wasting time and money.
That sums it up perfectly. It's why any sound legal strategy today guides clients firmly away from the K-3.
Which brings us, logically, to the paths people should be taking, the preferred options, the gold standard, as you called them earlier.
Exactly. We need to shift focus now to the strategies that couples really need to understand and utilize. The conditional resident, CR, and the immediate relative, IR visas. These are the definitive, reliable pathways to permanent residency.
Okay, CR and IR. And you said these are the preferred routes because they deliver the end goal, the green card, permanent residency immediately upon arrival.
That's the immediate, huge advantage, stability. Unlike the K-3, which puts you in a temporary status needing folder steps, both CR and IR visas are immigrant visas. They grant lawful permanent resident status the moment you enter the U.S. with that visa stamp.
No complex adjustment of status needed later inside the U.S.
Correct. It avoids that whole I-485 process entirely. That's a major benefit in terms of time, cost, and stress.
Okay. So if both CR and IR grant immediate permanent residency, what's the difference between them? You mentioned the central decision point.
The central decision point, the factor that differentiates CR from IR, is simply the duration of the marriage at the exact time the green card or immigrant visa is actually issued or granted.
How long you've been married when you cross the finish line, basically.
Precisely. Let's break down the conditional resident or CR visa first.
Okay, the CR visa. When does this one apply?
The CR visa is applicable when the couple has been married for less than 2 years on the day the foreign spouse either gets their immigrant visa approved at the consulate or, if adjusting status in the U.S., the day the green card is approved.
Less than 2 years of marriage. And why is the residency only conditional? What does that mean?
It's conditional because, from the perspective of U.S. immigration law, a marriage under 2 years old is still considered relatively new. So they grant permanent residency, but with a condition attached as a sort of fraud prevention measure.
A check to make sure the marriage is legitimate and ongoing.
Exactly. It's basically to ensure the marriage wasn't entered into just to get immigration benefits. The condition means the green card granted is only valid for 2 years initially.
Only 2 years.
Yeah.
Okay. What happens then?
Well, the crucial thing is that this 2-year period acts like a mandatory probation or audit period. If the couple were to divorce or legally separate during those 2 years, the foreign spouse generally loses their permanent resident status and their path forward, unless they can qualify for a special waiver, which difficult.
Right. So staying married is key during that conditional period, and that leads directly to the next required step, doesn't it? Removing the condition. How involved is that process 2 years later?
It is arguably the single biggest administrative burden associated with a conditional resident path. It's a major hurdle.
Okay. What do they have to do?
Within the 90-day window, immediately before that 2-year conditional green card expires, the couple must jointly file Form I-751, petition to remove conditions on residence.
File Form I-751 within that specific 90-day window.
Yes, jointly file it. Missing that deadline can have severe consequences, potentially leading to termination of status. And filing it requires, well, a lot.
What kind of lot?
Yeah.
How heavy is this administrative burden?
It's immense. They essentially have to reprove their marriage all over again, but this time with evidence covering the 2 years they lived together in the U.S. as conditional residents. They need to submit substantial evidence, the proof of bona fides, showing the marriage is still ongoing, genuine, and that they've built a shared life.
So it's like I-130 round 2, but with 2 years of U.S.-based evidence.
That's a very good way to put it. It's often even more scrutinized than the initial I-130.
What specific kinds of documentation are we talking about here? What proves an ongoing shared life over 2 years?
Oh, it's comprehensive. You need overwhelming proof of commingling. We're talking things like joint federal and state tax returns filed for the 2 years they were conditional residents, joint lease agreements or mortgage documents showing they lived together continuously.
Okay, taxes, housing.
Joint bank account statements showing regular combined financial activity, not just a dusty account opened once. Joint credit card statements, titles for cars owned jointly, joint car insurance policies.
Insurance, finances.
Birth certificates for any children born to the marriage during that time, utility bills in both names, gas, electric, water, internet for their shared residence, life insurance policies, health insurance, retirement accounts showing each other as beneficiaries, even things like travel itineraries for trips taken together, photos spanning those 2 years, affidavits from friends or employers confirming the ongoing relationship.
Wow, that is an extensive list. You really have to document your entire shared life for 2 years.
You absolutely do. And our legal team often emphasizes the psychological toll this takes. Having to meticulously save every joint bill, every statement, knowing you face this big government audit of your marriage 2 years down the line. It adds a layer of stress. Many couples, in hindsight, wish they could have somehow waited just a bit longer to qualify for the other path.
Which brings us to that other path, the immediate relative, or IR, visa. This sounds like the strategically preferred outcome if possible.
It absolutely is. The IR visa is the most streamlined, most desirable long-term path if you qualify.
And how do you qualify? What's the trigger for the IR visa instead of the CR?
Simple. The IR visa is applicable when the couple has been married for over 2 years on the day the green card or immigrant visa is issued.
Over 2 years. So that 2-year anniversary mark is the magic date.
It is the critical threshold. If your marriage crosses that 2-year mark before the final visa adjudication happens, you shift from the CR category to the IR category.
And the immediate massive advantage of hitting that IR category is...
The advantage is huge. The IR visa grants an unconditional 10-year green card right from the start, immediately upon entry.
a full 10-year green card, not the 2-year conditional one.
Correct, which means they completely bypass the entire conditional residency period. And crucially, this means they entirely avoid having to file the Form I-751 later on.
No I-751 required at all.
None. That entire second hurdle, that mandatory 2-year audit with all the documentation and stress we just discussed, it's completely eliminated.
That saves substantial time, thousands in potential fees for the I-751, and just removes that 2-year cloud of having to reprove your marriage.
Precisely. That's the primary reason our legal team always advises clients, if timing allows and the marriage is approaching that 2-year mark, to strategically think about whether delaying the final step slightly could push them over that threshold into the IR category. The long-term benefit is significant.
That makes perfect sense. The stability, the lack of future hurdles, it's clearly the better position to be in.
There are just too many visas out there, and I don't know which one is right for us. We need to get the right advice.
Communication is everything, and I just need someone who will listen and guide me to the right visa type, and not make promises that they can't deliver.
There are so many documents. I need someone to walk me through each one. I can't afford to make any mistakes.
If I can just find a lawyer who understands my potential, I know America will be an excellent opportunity for me and my family.
Welcome to the law offices of Chris M. Ingram, and we are your immigration lawyers, and we will be with you every step of the way in your immigration journey.
At the law office of Chris M. Ingram, you get a free consultation so we can understand your needs.
We don't make promises we can't keep. Our success rate speaks for itself.
Join us and access your step-by-step video guides that answer every visa question.
Their platform is amazing. There are videos that instruct you on everything you have to do. It meant we were in control and we could do it in our own time.
They couldn't have been more helpful. They answered every question that I had, and it was easy to see they were the lawyers for me.
I couldn't believe it with my busy schedule. They always had time to talk to me and put me at ease. That's what I like about them.
So go on our website and get your free consultation now, and your new life is about to begin.
Ask me.
We did it! We did it! We did it!
Oh my God, I got my visa! Yes, I did it!
Now, let's quickly compare the immediate rights upon entry. You mentioned CRR holders have advantages over K-3 holders right away.
Yes, a big difference in terms of seamless integration into U.S. life.
How so?
Both CR and IR visa holders, because they are entering as lawful permanent residents, are granted immediate, unrestricted work and travel rights the moment they arrive in the U.S. and are processed through immigration.
They can work right away. Travel freely?
Yes, their passport gets stamped with temporary evidence of permanent residency, or they receive their physical green card shortly after. There's no need to file those separate applications for an EAD work permit or advance parole travel permit.
Unlike the K-3 holder, who we established has to apply separately for those and wait for them to be approved.
Exactly. The K-3 holder faces weeks or months of waiting after arrival before they can legally work or safely travel internationally. CR and IR holders can hit the ground running.
That clarity and efficiency just further solidifies CR and IR as the only really sensible options today, doesn't it?
Without a doubt. Strategically, the focus should always be on the CR or IR path.
Okay, great. So we understand the what's and the why. Let's move into the how. Let's get into the deep mechanics of the immigrant visa process itself, the common steps required for both the CR and the IR visas. Let's emphasize the details our researchers gathered that listeners really need to know.
All right. The immigrant visa process, whether it leads to a CR or an IR visa, generally follows three main phases. It's a sequential process, and it starts with the U.S. citizen petitioner.
Phase 1, what is it?
Phase 1 is absolutely foundational, filing the I-130 petition with USCIS. The U.S. citizen's spouse must initiate the entire process by filing Form I-130, petition for alien relative, with U.S. citizenship and immigration services.
This is the petition we mentioned earlier, the one that establishes the relationship.
Correct. This petition's purpose is to legally establish that a valid marriage exists between the U.S. citizen and the foreign spouse. And our legal team always stresses this. The strength of this initial I-130 filing is paramount. This is often where cases are won or lost, or at least significantly delayed.
Delayed how? What's the risk here?
The risk is getting a request for evidence, or RFE, if the evidence submitted with the I-130 isn't strong enough, or if USCIS has questions about the legitimacy of the marriage, they'll issue an RFE asking for more proof.
And an RFE means delay.
Significant delay. Responding to an RFE adds months to the processing time. So getting the initial I-130 filing right with robust evidence is key to a smooth process.
Okay, let's expand on that required evidence for the I-130. It's not just the marriage certificate, right? What are they looking for to prove a bona fide marriage? And what are common mistakes couples make?
Right. The marriage certificate just proves a legal ceremony took place. USCIS needs proof that you intend to build or are building a life together. It's about proving the intent and the reality of the relationship.
So showing commingled life.
Exactly. A common mistake is providing only superficial evidence, maybe just the certificate and a few wedding photos. That's usually not enough.
So what does a strong evidence package look like?
A strong petition includes layers of proof, definitely proof of joint finances, things like joint bank account statements showing deposits, withdrawals, shared expenses over time, joint credit card statements, evidence of joint savings or investments.
Financial ties.
What else? Proof of joint residency is crucial. If you live together, copies of your lease agreement or mortgage documents with both names. Utility bills, gas, electric, water, cable addressed to both of you at the same address. Driver's licenses showing the same address.
Shared home.
Evidence of shared responsibilities and planning for the future. Things like joint auto insurance policies, health insurance policies where one spouse is on the other's plan, life insurance policies naming each other as beneficiaries, wills, powers of attorney.
Planning together. Makes sense.
And then there's the relationship history. Comprehensive photos, not just the wedding, but photos together over time, with family, with friends, on trips, documenting the progression of your relationship. Copies of emails, chat logs, letters, phone bills showing you communicate regularly, especially if you lived apart for some time. Travel itineraries from visiting each other.
Telling the story of the relationship.
Precisely. You need to paint a picture of a genuine, ongoing marital union. The strategic advice from attorney Chris Ingram's team is always over-document rather than under-document the I-130. Front-load the evidence to minimize that RFE risk.
You also mentioned affidavits earlier, sworn statements from family and friends. How valuable are those in the I-130 package?
They can be very valuable, especially if some of the joint documentation is maybe a bit thin, perhaps for a very new marriage or complex living situation. Affidavits provide important third-party validation.
Social proof.
Exactly, social proof. But a good affidavit isn't just, I know them, they seem happy. It needs specifics. The person writing it, the fiant, should state how they know the couple, how long they've known them, how often they interact. They should describe specific interactions or observations that made them believe the marriage is real, maybe seeing them support each other, manage household tasks together, discuss future plans. Details make the affidavit credible.
Okay, so a well-documented I-130, potentially bolstered by strong affidavits, gets filed with USCIS. Assuming it gets approved without an RFE, what happens next? Where does the case go?
Once USCIS approves the I-130, the case moves out of their hands and into Phase 2, National Visa Center, NVC processing.
The NVC, what's their role?
The NVC is part of the U.S. Department of State. They basically act as the clearinghouse, the document collection agency, preparing the case for the final consular interview abroad.
So more paperwork.
Yes. This is where the bulk of the civil documents and financial documents are submitted and reviewed. The couple, primarily the foreign spouse applicant, will need to submit things like their birth certificate, police clearance certificates from countries where they've lived, passport photos, and pay the necessary visa processing fees.
Civil documents, fees. And you mentioned financial documents.
Yes, and this is a huge part of the NVC stage, the affidavit of support.
The I-864, we touched on this. Let's dive deeper. The U.S. citizen has to file this.
Correct. The U.S. citizen petitioner must file Form I-864, Affidavit of Support. This is a legally binding contract with the U.S. government.
A contract stating what?
Stating that the petitioner has adequate financial means to support the intending immigrant spouse, and promising that the spouse will not become a public charge, basically, reliant on government welfare benefits.
Okay, and how do they prove adequate financial needs? Is there a specific income level they need to meet?
Yes, there's a very specific threshold. The U.S. citizen petitioner's current annual income must generally meet or exceed 125% of the federal poverty guideline for their household size.
125% of the poverty line. What does that translate to in dollars?
Well, the guidelines are updated annually, usually in the first quarter of the year. Using the most recent figures and projecting slightly for 2025 estimates, our researchers calculated that for a household size of 2 people, the U.S. citizen and the intending immigrant spouse, that 125% benchmark is approximately $19,125 per year.
Around $19,125 for a household of 2. And that amount increases if there are other dependents in the household.
Exactly. The required income goes up for each additional person included in the household size calculation. You can find the exact figures on the USCIS website for Form I-864P.
What happens if the U.S. citizen petitioner doesn't meet that income requirement on their own? Is the case dead?
Not necessarily, but it adds a significant complication. If the petitioner's income is insufficient, they usually need to find a joint sponsor.
A joint sponsor, who can that be?
A joint sponsor must be another U.S. citizen or a lawful permanent resident, usually a family member or close friend, who is willing to also file a Form I-864, taking on the same legal financial responsibility for the immigrant spouse.
So someone else steps up to guarantee financial support.
Yes. And that joint sponsor must independently meet the 125% income requirement for their household size, including the immigrant spouse they're agreeing to sponsor. They also have to provide proof of their income, usually tax returns, and proof of their U.S. status. Finding a willing and qualified joint sponsor can sometimes be challenging for couples.
I can imagine. And the petitioner still has to submit their own financial proof too?
Yes, the petitioner typically needs to submit their most recent federal income tax return transcript from the IRS, along with evidence of their current income, like pay stubs or an employment letter, to back up the figures on the I-864. Consistency is key.
Okay, that I-864 is clearly a critical, quantifiable hurdle that needs careful preparation. So once the NVC has collected all the civil documents, the fees are paid, and they've approved the affidavit of support. What's the final stage? The final stage is Phase 3, the consular interview. Once the NVC determines the case file is documentarily complete, they schedule the interview and transfer the entire file to the appropriate U.S. embassy or consulate in the foreign spouse's country of residence.
This is the interview the foreign spouse attends.
Correct. This is often seen as the moment of truth.
Feeling lost in a maze of visa types and paperwork? Don't know where to turn? We've got your back. With clear answers and real help, we'll guide you every step of the way. Let's navigate it together. Your journey starts today.
Hello, you must be Clara. Welcome to the law office of Chris M. Ingram.
Finally, I found a law firm that will help me achieve my American dream.
At this law firm, you are important to us. That's why we will be with you every step of the way. So join us at the office of Chris M. Ingram.
The foreign spouse goes to the embassy or consulate for a scheduled interview with a U.S. consular officer.
What happens at the interview? What's the officer looking for?
The officer reviews the entire application package, verifies the spouse's identity, takes biometric data like fingerprints, and asks questions. The questions typically cover the applicant's background, eligibility for the visa, checking again for any inadmissibility issues related to health, crime, security, etc., and very importantly, the authenticity of the marriage. They ask about the relationship again.
Yeah.
Even after the I-130 was approved.
Absolutely. They want to be personally satisfied that the marriage is legitimate and ongoing. They might ask how the couple met, about their wedding, daily life, future plans, details about each other's families. If there are any red flags or inconsistencies, they can probe quite deeply.
So preparation for the interview is key.
Very key. Being honest, consistent, and prepared to talk openly about the relationship is crucial. If the officer is satisfied, they will typically approve the visa.
And visa approval means they can finally come to the U.S. as a permanent resident.
Exactly. They'll get the immigrant visa stamp in their passport, usually valid for entry within 6 months. Once they enter the U.S. with that visa, they officially become a lawful permanent resident, either conditional CR or immediate relative IR, depending on the marriage duration.
Okay, that walks us through the whole KIRR process. Now let's just quickly reiterate that efficiency comparison, especially with the timeline data, to really drive the point home about why KIRR is the standard versus the K-3.
Right. The numbers really tell the story. In fiscal year 2023, the U.S. government issued over 88,000 CR and IR immigrant visas combined.
88,000 compared to 6 K-3s.
Exactly. It shows where the operational focus is. This is the main high-volume functioning system for spousal immigration.
And the timelines.
The timelines, while subject to variation, are generally predictable. A conditional resident CR visa process from I-130 filing to visa issuance typically takes somewhere in the range of 9 to 14 months.
9 to 14 months for CR.
And the immediate relative IR visa process tends to take slightly longer, maybe around 15 months on average, sometimes a bit more, possibly due to minor administrative differences or maybe slightly more scrutiny given the direct 10-year green card.
Okay, so let's say roughly 9 to 15 months for these stable permanent residency paths. And the K-3 timeline.
The K-3 timeline, based on historical data when it was used more, was already unreliable, maybe 8 to 19 months, but that's almost irrelevant now because of the extremely high risk of denial, that 68% rate, or administrative closure before it even finishes. It's just not a reliable metric anymore.
So the conclusion seems inescapable. The KIRR paths offer predictability, high volume, and lead directly to permanent residency within about a year to a year and a half, whereas the K-3 is statistically insignificant, risky, and likely to be terminated.
That's the strategic reality based on the data and process mechanics. The logical choice is clear.
Which brings us perfectly to our synthesis. Let's tie all this information together now, focusing on strategy, stability, and the path forward. We firmly established CR and IR as the superior, really the only viable, routes. Let's really make the argument now for why couples should strategically aim for that IR visa, if at all possible.
Okay. The core argument for preferring CR/IR over the K-3 is already clear. Immediate permanent residency, immediate work and travel rights, avoiding the complex I-485 adjustment later. That's huge.
Right, stability from day one.
But the argument for strategically aiming for the IR visa over the CR visa, if your marriage duration allows, centers squarely on avoiding the significant burden of that Form I-751 petition to remove conditions.
Avoiding that 2-year follow-up audit.
Exactly. Let's reemphasize what that I-751 entails 2 years after you arrive. It's not just filling out another form. It's a mandatory, high-stakes re-adjudication of your marriage.
High stakes how? What if something goes wrong with the I-751?
If the I-751 isn't filed on time, within that 90-day window before the 2-year card expires, or if it's filed but the evidence isn't deemed sufficient by USCIS, or if they suspect the marriage is no longer bona fide, they can deny the petition.
And denial means?
Denial means the conditional residency is terminated. The person loses their green card status and is typically placed into removal proceedings, deportation proceedings.
Wow. So failure at the I-751 stage means potentially having to leave the country.
Yes. The pressure to maintain absolutely meticulous records of your shared life for 2 solid years. Every joint bank statement, every shared bill, proof of cohabitation, knowing that your entire ability to remain in the U.S. hinges on successfully navigating this second application. It's a significant psychological and administrative weight.
I can absolutely see that. So while the CR visa gets you permanent residency, it comes with this 2-year probationary period and a very demanding final exam in the form of the I-751.
That's a perfect way to describe it. A demanding final exam?
Whereas the IR visa, achieved by being married over 2 years at the time of approval, lets you skip that exam entirely. You get the full 10-year green card immediately, offering complete peace of mind from the start regarding that specific hurdle.
Exactly. And that's why our legal team considers the IR path the true gold standard. It offers not just residency, but immediate unconditional stability and a clear path forward without that looming I-751 requirement. It's about selecting the most secure and least stressful route available.
So choosing the right visa really is about strategy, not chance. It's about understanding these timelines, these requirements, especially that 2-year marriage mark, and making informed decisions.
It's about crafting a tailored plan for success, using the reliable highways, the CR and IR paths, rather than gambling on that dusty, closed-off K-3 trail.
Okay, one last clarification on the K-3, just to hammer it home. We mentioned the risk of administrative closure if the I-130 gets approved first. For those few who might still contemplate it, what actually happens to their case if the K-3 is administratively closed? Do they just start over from scratch on the JAR path?
Essentially, yes, but not quite from scratch. When the K-3 is administratively closed because of the underlying I-130 has been approved, the approved I-130 petition is then typically forwarded directly to the National Visa Center, NVC.
So it skips back to phase 2 of the immigrant visa process we discussed.
Exactly. The case effectively converts from the defunct K-3 track onto the standard Career immigrant visa track, starting at the NVC stage, document collection, affidavit of support, etc.
So they don't have to refile the I-130?
No, the approved I-130 remains valid, but they've still wasted the filing fee for the I-129F, the K-3 petition, potentially other associated costs, and definitely wasted months of time pursuing a pathway that ultimately just merged back into the standard process anyway.
Having gained absolutely nothing but delay and lost money.
Precisely. It underscores why it's strategically unsound from the outset in today's processing environment.
That is incredibly clear, thank you.
Yeah.
I feel like we've really unpacked the definitions, the history, the mechanics, and most importantly, the current strategic reality of these 3 spousal visa options. We've definitively shown why the K-3 is obsolete and why the focus must be on the conditional resident and immediate relative visas.
Absolutely. And that really lays the foundational knowledge, the strategic framework that anyone embarking on this journey needs to have. That wraps up part 1 quite nicely, I think.
Agreed. It sets the stage perfectly. So let's give our listeners a preview. What can they expect in the next deep dive part 2 of this series? They're focused on CR/IR now. What comes next?
Right. So part 2 is where we get intensely practical. We'll move beyond the what and why and into the how-to of execution for the CR and IR processes.
More hands-on guidance.
Definitely. We're going to dedicate significant time to mastering that crucial consular interview. We'll talk about how to prepare mentally, the types of detailed questions couples should anticipate about their relationship history and daily life, and how to present your case confidently and honestly to the consular officer.
Interview prep is huge. What else?
We'll also touch upon potential cultural and regional considerations that can sometimes influence how cases are perceived or processed at different embassies. And we'll discuss some common challenges and solutions, things that frequently pop up in these international cases, like dealing with missing documents, addressing previous visa denials, or navigating complex family situations.
Real-world problems and potential fixes.
Exactly. And perhaps most valuably, we're going to illustrate the entire CRR journey using 2 detailed concrete scenarios based on the kind of cases our research team often sees. We'll walk you through Anna and Michael's conditional resident CR visa journey from start to finish.
Okay, a CR case study.
And then we'll contrast that by walking through Maya and Manjeet's immediate relative IR visa experience. By comparing those 2 scenarios step by step, listeners will get a really tangible feel for how the process unfolds in practice, turning the theory from today into a practical roadmap.
That sounds incredibly helpful, seeing the theory applied to realistic examples. It will really bring the CR and IR processes to life. Definitely an essential listen for anyone moving forward.
We certainly hope so. It should provide that next level of practical detail.
Fantastic. Well, that's something to look forward to. Thank you so much for being with us today. We really hope you gained a lot from this discussion in part 1.
We hope it provided some clarity on these important pathways.
Please, if you found this valuable, subscribe to or follow this channel. It truly helps us reach and help more people navigating these complex situations. We'd greatly appreciate your support. And leave us a comment if you can. We love hearing from you.
Your engagement really matters.
Also, don't forget to follow us on YouTube, LinkedIn, Facebook, X, and Instagram. Our social media team is doing great work, and we're growing rapidly on those platforms thanks to them.
Lots of good content there, too.
Absolutely. And we would also like to once again thank attorney Chris Ingram and his dedicated team. Their thorough legal research was absolutely essential for preparing this presentation today.
Their expertise is invaluable.
It truly is. And finally, if you, a friend or a family member, are facing an immigration challenge and would like a free, personalized consultation, please visit our website at www.breakthroughUSA.com. You can schedule an appointment right there.
We'd love to hear from you and help you if we can.
We really would. Okay, that's all for this Deep Dives. Bye for now.